I had done pure litigation or negotiated divorce, and a couple of good friends of mine highly recommended collaborative when it came to Milwaukee, came to Wisconsin about 13 years ago. And I went to one of the first sessions for training for it and did not get it at all and did not want to do it. And it took about a year until I had an opportunity to watch people that I respected quite a bit do this work, and then I decided I'd take a chance on doing it. I really could not understand why we would allow our clients to not be able to go to court. And now I can't understand why we would want our clients to go to court. I think the quality of the lawyers who do this work means a lot. And what I've come to learn is that it's also the quality of the three legs of the stool, the mental health professionals and the financial neutrals that we lawyers work with really help make a case successful. And that's the model that we use to involve those three professions in working toward a successful case. And it takes that kind of support. And anybody who knows how to problem solve knows that getting more information, best professionals at the lowest price possible to do the best work possible is the best way to solve a problem. And I think that's key to the collaborative process. Because it's not easy to get people who are going through divorce, who are hurting, who are having a difficult time making a lot of very tough decisions, who aren't thinking clearly because their emotions are clouding their judgment, to do that hard work. And so we find it's often very difficult to invite people to come back to meetings. Most people would like their doctor to take care of their health problem and cure them and give them a pill. Most people would like to hire a lawyer because we're expensive and ask them to solve the problem. Call me when it's done. So in the collaborative process, if we are asking people to allow us to work with them, to really understand how they want to get the problem solved, we're asking them to work and think on something that they would just as soon push away. And so I think our job is to not over-meeting them, over-task them, but to say, you'll be a partner in how we make decisions. You'll know the decisions that are being made. We will encourage you to develop a voice. We'll have a mental health coach who will help you either talk about it or work on it or speak for you when you can't speak any longer. We'll have a financial neutral do as much as they can with you, but also initiate some suggestions so that you don't have to make every decision. Your lawyer doesn't have to fight for something that you don't think is right. If we have a traditional divorce where parents are not able to agree about either custody or placement, and their lawyers can't solve the problem, and a third lawyer called a guardian ad litem is appointed to represent the best interests of the child or the children. And that sounds good, doesn't it? The best interests of the child. This is going to be a lawyer who's going to help the child and help the parents. That guardian ad litem is appointed by the court. Both parents and their lawyers know that that guardian ad litem will be part of a court process and be reporting what is said, what's observed. And that creates a couple of different practices that aren't as healthy. It means that there's lobbying going on. It means that the children are involved often in what is the dispute as opposed to solving the problem. It means that they know that what they say will be reported in some way, probably to their parents, certainly to a judge, and there's another lawyer who's been involved, and now they've really been brought into the litigation. That's not often a healthy process. In a collaborative case, some of the same things happen. If they're going to have a neutral child specialist and coaches, well, one of the similar things is that kids know they're going to be seeing somebody new. Now, kids don't like to do that. They don't want to be seeing somebody new. But the mental health professionals that we have, particularly in this state, and the lawyers who recommend to them, know and have found that once children are working with a neutral child specialist, they're probably going to be asked to be not in the middle of their parents' dispute, but a consultant to the child specialist who's trained in human behavior to help the children and the parents work on a plan that works well for all of them. And what we found is that kids love to be consultants. You know, in a traditional divorce, everybody wants to keep the kid out of the courtroom. The theory is that the child won't be involved in the dispute, the child won't talk to the judge, so we want to insulate the child. That's what our statute asks us to do, but that's not what happens. The child gets right into it. In a collaborative case, the child is going to be listened to. We all know that the child wants to have a voice, but not in a way that's judgmental against the parents. They want to have a voice that says, here's what I see happening and here's what I think I can do, and I'm inviting you, my parents, to talk about what's best for me, with a professional. So there's a very big difference with kids. Well, I think that both the older practitioners in collaborative divorce, whether we're lawyers or financial or mental health people and counselors, or the younger ones who are members in collaborative, have a different focus on what the law means to them. You know, when you get older, you don't want to fight so much. You want to solve problems and you want to see better situations develop. But collaborative has also attracted a lot of young practitioners in these three fields. And again, I think it's sort of a signature profile for practitioners in this area to say, as lawyers, we are very interested in bringing a better way of living to our client community. And if we work on this process, by the way, we learn a lot. We are constantly learning about human behavior when we do this kind of work. It's complicated. It's like peace negotiations. It's difficult. But it's a very satisfying way to solve the problem. It may not give you that immediate high of walking out of court with a win. That adrenaline rush may not be there at quite the highest level. But as far as long-term satisfaction that we see in our client families and in ourselves, it's the reason we do it.